Today we have our president, Matthew Turk, speaking, and we have tuba practice outside. Matthew's been our president, I guess this is your 6th year, I guess your last year, so this will be your last Research at TTIC talk, and he'll be telling us today about intellectual property.
Is this your view?
Yeah, so I started with my background here on purpose because David and I had this conversation some years ago about whether you could actually see Michigan from my condo. So this is a view looking east from my condo building, and this light here and some structures in here are in Michigan. So finally brought you proof after all these years.
You calculated the angle based on your floor level.
Yeah.
And I think you decided it was possible.
Yeah. It's a 62nd floor, but anyway, let's see. We'll keep with the tuba practice out there. So I've talked with several TTIC students and some RAPs over the past couple of years about mostly patents, maybe copyright a little bit here and there, and I just thought it'd be kind of fun to do a research at TTIC session about intellectual property. So this is not a research talk. It's sort of a research adjacent talk, I guess, in a way. But I think there's a lot that is relevant to us and what we do in our communities and all regarding intellectual property and its relation to the research ecosystem in general, and then just some sort of details about patents and copyrights and such that you're likely to care about at some point. Get the right view here. Hold on. Okay. So here are the kinds of questions that you might hear or you might even have at times, about, I do research, who owns it? And what about my data? And is my code protected? Do I want it to be protected? And all kinds of questions come up that are, either more or less, but somewhat related to intellectual property. I'm not going to cover all of these, but this is sort of a discussion about the undercurrent for a lot of questions like this. I think you all know that copyright is a really big deal these days with AI models and generative AI systems. For example, there was a request for information recently from the US government, basically driven by the Trump administration's new AI policy and how they're going to be developing things. And typically the government gets, dozens or maybe a couple of hundred responses to RFIs like this. This one they got over 10,000 responses to, over like 18,000 pages of response. So there's a lot of interest in the world right now about these models and about what the government's doing and how intellectual property might or might not be protected. And a lot of those responses, in fact, were from artists who were concerned about their intellectual property. So anyway, it's a big deal. In general, I think intellectual property is just part of the research ecosystem. And I'm going to be focusing mostly on the US today, say a couple things about international. But in terms of the US research ecosystem, we have these kind of main players, academic institutions, industry, nonprofits, government agencies, other kinds of research infrastructure that might be funded by government agencies or others. And that includes, things like Argonne National Labs, but also includes big projects, large telescopes in space and things like that. And then we have people and money, essentially, that drives a lot of things, all undergirded by sort of a set of laws and policies and norms that these various interactions are sort of built around. And in general, sort of prototypical situation, prototypical narrative is that great ideas emerge from us, basic research and places doing that. And then through grants, through IP protection, through tech transfer, these ideas enter the world through startups, through corporate innovation, other sorts of things. VCs, incubators, companies fund and accelerate these sorts of possibilities, and the technology then goes somewhere eventually, and at the end of the pipeline sort of feeds back in some ways at least to research. Our field or our fields get funded because of this ecosystem and because people are convinced that there's value in it, and it increases productivity and things like that. So it is very cyclical in some ways. And this is a diagram from over 10 years ago, over 12 years ago, from the National Research Council. And it basically was done just sort of illustrate for the general public and for lawmakers and such, the relationship between the red lines in various areas of fundamental research starting at a certain point in time, and then the blue lines of more industry R&D, more applied research and then development, and then the red black dots and green lines are actual products, and then products becoming more valuable. The narrow green line is a $1 billion market. The thicker green line is a $10 billion market. And so to some degree, this just shows the relationship between, in many cases, decades in advance, research was invested in, and decades later, these advances started to actually impact industry, and then sometime after that, actually became significant markets. And that story can be told about a lot of other areas besides these that are in the particular diagram. But it's a good message to the public, just kind of remind people who vote and who eventually will sort of have some say about research funding that the red lines there are really important. So I always like to say a few things personally when I give a talk. So I've been involved in some things that I kind of view as, part of one of those combinations of red and blue and green threads. So one of them for me was work I did right after my master's degree, before my PhD. It was one of the first main US projects on autonomous vehicles, or self-driving vehicles. And we had this huge hunk of a thing full of computers. We could actually stand and ride in it and start the computers and things like that. And it would go like 2 or 3 miles an hour on these back roads and around Denver, Colorado. But it was pretty cool. Nobody else hardly was doing that sort of thing back then. And then, of course, years later, now we have real autonomous taxis and such, right? And I got to ride in one for the first. How many of you have ridden in an autonomous taxi? Just curious. Not very many. Okay. So I was in Phoenix maybe 3 weeks ago, and I got to ride in one for the first time. So here's a little video of me sitting in the passenger seat with the invisible driver. This is Waymo, yeah, in Phoenix. And as you can see, there are a lot of Waymos on the road. There's another one just passing us right there. And it was really personally satisfying to have been involved in this research decades ago. I won't tell you how many decades, but many decades ago. And then, 3 weeks ago, to be able to finally sit in a commercial product doing what we were envisioning decades ago. And so that kind of thing is pretty fun. Another thing is I did my PhD on face recognition. And we have a member of our EAC, Takeo Kanade, who did it a decade or two before me. That was just research for curiosity back then, primarily, with a few little applications. But nowadays it's all around the place. Sometimes it's very problematic and there's a lot of concern about it, but it's still sort of all around the place in various kinds of applications. And it's expected to be one of those fat green lines before too long of being $10 billion market or larger, maybe even is right now. So that was kind of interesting to be, very early stages of something and then see it become, commonplace years later. And then when I was at Microsoft Research years ago, I worked on various things regarding looking at people and understanding their gestures and movements and body structure and things like that. And then some years later, Microsoft came out with the Kinect and various applications and games and such with the Kinect. I personally didn't have anything directly to do with the Kinect, but the work that I and colleagues were doing influenced significantly Microsoft's direction in getting there. So that was kind of neat to see. I think that came out in 2011.
Is that you in the?
Oh yeah, that's Bill Gates and me. And then when I was at UC Santa Barbara around 2014, a PhD student and I did a startup company. It was based on augmented reality, and basically augmented reality to support collaboration of remote people on certain kind of physical tasks and problems. And that startup got acquired, and it became became this product called Vuforia Chalk that this company in San Diego sold and marketed, and sort of became a big deal for them. It's a little example of two technicians, or like the technician and the boss sort of working remotely on a physical problem. And that was kind of cool because that was a much more direct involvement. You know, we worked on something that was NSF funded, that Stefan, who I think I'll show you in a minute, his PhD was based on. And then this product, you know, was basically directly from that. So it was really nice to have that kind of very direct interaction there. So in these things, three of these things I just mentioned had patents involved with them. Some were a little more important, some were a little less important, but they were focused to some degree on patented IP. And then in addition to those experiences that I just mentioned, at UC Santa Barbara, I did a pretty good amount of patent-related consulting, basically. So dealing with various patent litigation, infringement, and other sorts of things. So we got a pretty good background through that of kind of the more legal aspects and you know, how much certain words matter and things like that, which I'm going to talk about a bit today as well. So anyway, all of that's just kind of background to say that intellectual property is really important, and the fundamental structure of intellectual property, at least in the United States, is the U.S. Constitution. In Article 1, Section 8, and there's another paragraph or something in there, but that's all it says about intellectual property in the Constitution. That's sort of the founding point of everything else. It's Congress shall have the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive rights to their respective writings and discoveries. From that comes a whole bunch of laws, including the Patent Act and the Copyright Act, federal agencies like the Patent and Trademark Office, the Copyright Office, and then all kinds of enforcement that goes on in courts, federal and state and local. So IP, again, plays an important part of the ecosystem that we're in. The root of IP is basically there. And what is it? It's really government-protected property. Property of yours, or of mine, or of somebody's, that can be protected by the government. And you know, lots of things can be done with it, which we'll talk a little bit about. So main types of intellectual property, you know, I'm sure you've seen this kind of thing before. Patents, copyrights, trade secrets, trademarks, industrial designs, geographical indications. Anybody know what a geographical indication is in terms of IP? Or an example of one?
Like Parmesan cheese has Parmigiano Reggiano cheese.
Yeah, or champagne. Yeah, that's a very classic one. There are a bunch of things like that. Kentucky bourbon, these things that, you know, are related to a particular location, and they, you know, have intellectual property protection because of that. You can't sell champagne if you made it, you know, in Chicago, right? You're not allowed to. You'll get sued for that. So that's that kind of thing. Industrial designs. I'll show you in a bit an example of an iPhone patent, which was sort of industrial design, not how it worked, but just actually the packaging. Trademarks, of course. Trade secrets. You know, just things that you don't tell the world, so they're secrets. But the main things that we'll talk about today are patents and copyrights. Right? These are sort of the main ways that people, at least in our fields, encounter intellectual property. And the general sort of academic institution situation is that We make intellectual property with what we do, or at least we can make intellectual property. The university generally owns, or the university or institute generally owns the IP for work created with their resources and under funding that they manage and things like that. But the inventors, students and faculty, should be able to receive a share of any licensing revenue, or should be able to, somehow benefit from their intellectual property if there is money or something that comes out of it. There are exceptions. If any of you here that are affiliated with TTIC create something that's sort of on your own time and on your own equipment with very minimal, TTIC support, then that can be carved out separately. But basically what you do as a student or faculty member here is owned by TTIC, but very easily licensed back to you. And there are some other things, coursework, lectures, course projects, things like that are not necessarily covered by this. So those things are generally not owned by the university or the institution, although there can even be occasional exceptions to that. So for TTIC in particular, I'm sure you all, the TTIC people here, I'm sure you all know and have memorized the intellectual property policy, right? Or maybe you've seen it once. You should have seen it once because you had to sign it. So here's the part. I think it's just like maybe 2 pages or so. There is a page at the end that this is the agreement that you all TTIC people signed, and I believe all students and employee faculty have to sign this. And so you probably forgot about it, but that's what you signed. And key thing here, it says, I do hereby assign to TTIC all of my ownership, right, title, and interest in any invention or discovery that I have conceived or reduced to practice. I further agree to fulfill my obligations of disclosure and cooperation in the patenting and commercial development of any such invention or discovery. So you have obligations. If you make an invention, particularly an invention that someone reasonable would see as valuable, you have an obligation to disclose that to TTIC. And then TTIC has certain obligations in terms of its relationship to that and to you, the inventors. How many times that has happened in TTIC's history is another question, but it's not very large, let me tell you. And then, so not the agreement, which that other text was from the agreement. This text now is from the main policy, and I won't go through all of it, but it basically talks about this disclosure, who you tell it to and how and things like that. By the way, I just noticed the other day that the link to the disclosure form was not working, so that's probably why we haven't had many of these over the years, but we're going to fix that any day now. Anyway, so yeah, we have, we have stuff about this, at TTIC, as does UChicago, as does any academic institution. Yes?
Do you happen to know how many patents there are with TTIC?
I believe there are 0 patents that have been pushed, that have been, what's the word, assigned to, or applied by or assigned to TTIC. Correct me if anybody knows that that's wrong. I believe that was
Was it not?
To TTIC or to you?
Is it exempt?
Oh, it's interesting.
I have many of
well, the ones I know about with you are the IBM ones, but you're talking about something else.
TRI.
And TRI, yeah.
But
those are all being assigned to TRI or IBM. I don't know if there's other ones that you're referring to.
No.
Okay,
I think
yeah.
TTIC, so I think on the situation, I think it comes up often. I think also with Adobe we may have had something like that a long time ago.
Possibly.
I think that there is an agreement at the institutional level, right? And TTIC has a right to look and decide whether they want to join in the patent or give it up and give it to the other institution.
Yes.
I
Or-
don't know if you're going to talk about the costs of this.
Just a little bit, but yeah. So to my understanding, at least so far, there's been no patent that has been applied for by TTIC or completely funded by TTIC or something like that.
And that's not because people have, I guess, there's evidence people have applied for patents, it's just that GTIC is waived.
Yes, so in several cases, we've waived our rights to,
Assign the rights back to them.
to own it and do things with it, and given them back to the inventors. And to some degree, although you probably should not quote me on this, that's kind of, the expectation at TTIC, but I wouldn't say in all cases. So here's an important thing in all of that. Why does that matter? Well, maybe because you might be able to make some money off of it. And so as part of this stuff is written in here. Like if we do decide to patent, or if we do make money off of your IP, you get some of it. Let's see, TTIC first reimburses certain things like the cost of the lawyers and the applications and all these kinds of things, but then we sort of give the rest of it back to ourselves or to the inventors at various proportions. And those numbers were a little more generous than average, but they're sort of fairly close to average for other American universities. All right, so, and we'll get more about patent stuff in particular, but let me talk a little bit about copyright. So under US law, works of software are just like novels, basically. They're literary works, and they are covered by copyright law. The text of your source files, and also, in fact, your object files and executable files are covered by copyright. And what is covered is not the functions that they do. What is covered is the actual bytes, basically. Okay, what you wrote, and then in the other code, the object code and stuff, what it gets compiled into and such. So it's the expression, how you express those things, the functions that you're trying to accomplish, not the functions themselves. That's what copyright is going to be covering. So it's the overall structure, sequence, organization, module names, your user interface look and feel, those kinds of things can be covered under copyright, but not the ideas or the functions being incorporated. There is also fair use. Some people can use your copyrighted code for certain limited things, or your copyrighted novel or whatever, but generally, you own it for your life plus 70 years. Okay, so it's term limited, but it's pretty long term, actually. And it's little different numbers for certain situations. So with that ownership of a copyright piece of something that is copyrighted, you can license it, right? And how many of you have done open source, have open source code? Okay, less than half, but okay, maybe about half. So a lot of you have probably gone through this question of which license to use and stuff like that. I'm not going to cover those really today, but as you probably all know, there's a pretty wide range. I mean, you can just refuse to license at all. It could be completely closed. You can just give it to the world, and it's completely open, and then a bunch of places in between, which tend to have various requirements, these places in between. If you modify it, you have to give that modification to everybody or not, or whatever. So anyway, the licensing itself can be very complicated. Yeah.
So what about a code which is semi-written by me and semi by ChatGPT? Can I still copyright it, or who OpenAI gets the right?
Yes, they do not. In fact, I'm going to come back to that in a bit, but the bottom line is that for copyright purposes, you have to be a human to get rights. So ChatGPT does not have any rights. There might be other fine distinctions about how it's used and stuff, but high level, I think that's probably the key thing. And one important thing to know, I think, about copyright is you've all seen notices like this, right? These are the copyright notices to the public that your code or novel or whatever is copyrighted. You actually don't need to do that. It's copyrighted automatically. If you wrote it, it's copyrighted for you. That's default. But it's a good thing to still do that, because the way it works in the courts and all that later on is it's harder for somebody to say, oh, I didn't know it was copyrighted. And there's certain things that can or can't be done, or certain punishments that can or cannot be meted, depending on whether you actually have that in here. So you don't need it for copyright, but you might want it anyway for good, strong, more solid protection. You can also register your copyrighted novel or software or whatever. You also don't have to do that. You don't have to get it to register it for it to be copyrighted. But it also helps. If you have registered it and done it early, like before somebody violates your copyright rather than after somebody violates your copyright, you're going to have better luck in court if you're going to sue them, basically. So it's still a wise thing to do. So if you register after the fact, after somebody has used it, then your damages remedies are a little more limited.
question?
Yeah.
So suppose you have a trade secret
Yes.
and you write that up, you write some stuff that you really don't want anybody to see.
Yep.
Is that under copyright if nobody has seen it at all?
No, copyright, like most intellectual property that we're talking about here, it's an agreement between you and a government about we will give you certain rights if you open it to the public in some ways. So if you just write something and put it under your mattress and never sees the light of day, I don't believe there is any, either there's no protection or there's no practical protection on that thing. So including trade secret stuff you're talking about.
I guess the converse question would be, if you copyright something, are you obligated to make it public? Or I don't know what it would mean to copyright something without it being public.
I think you're obligated not to hide it. I don't know exactly, what you're obligated to do beyond that. That's a good question. And patent will be very clear about that answer, right? But copyright, I'm not so sure. And I won't belabor this because we all, I think, know how big a deal this is these days. But copyright and models and generative AI, data scraping, text prompts, does OpenAI own your text prompts? There are all kinds of interesting questions. And just recently, over the last year and a half, the Copyright Office in the US has put out two and will be putting out a third report related to these sorts of questions. The first was about digital replicas or, put out a video of me that's not really me saying something, stuff like that. The more recent one in January of this year was about generative AI, and there'll be a third one coming out before too long. So the government, the court system in general is sort of plodding through, trying to make some headway to clarify this world, but of course it's changing daily and it's very hard to do.
Yeah. Are these these are recommendations, they're not law?
They're not making law, certainly, but they're saying what their policies are, how they're interpreting certain words. And so, for example, the fact that an output of generative AI, if you just type in a prompt and you get an image output from Midjourney or something like that, that is not copyrightable. But there's certain things that could be copyrightable, like if you did a bunch of prompts and got a bunch of images and then arranged them in a certain way or whatever, that might be. So there's definitely a gray area in there. And again, it's evolving day by day. So let's go on to patents then. There have been very interesting patents in the history of patenting. A dust cover for dogs, pretty cool. A fresh air breathing device and method in which you stick a pipe into your toilet. What? A patent was granted for this. A shark protector suit. You should all wear these if you go swimming in Lake Michigan. No sharks there, but a beer umbrella. A wearable device for feeding birds. A fork with a timer. There are a lot of innovative ideas out there.
Can you tell us why the Patent Office no longer requires nor allows sending a model of the device that we're patenting?
I do not know that.
Because too many fires were started.
Okay, that's believable. True? Interesting.
It
So maybe a little more practical. There have been patents on other things that you know quite well. Patents on the telephone, the light bulb, flying machines. Who's this patent issued to? Wright Brothers. Wright Brothers. Transistor. I bet you don't know who this one is issued to because I did not recognize the name either, and it probably never made any money or anything. But artificial neural networks, personal computer. Wi-Fi, Amazon's e-commerce methods, PageRank, SIFT, Viola Jones, the iPhone. This is the design patent. It starts with a D. So this is the actual design of the iPhone, not how it works. But so yeah, a lot of really kind of important things were patented, and some of those probably made lots of money. Some of them didn't make any money.
So with the iPhone patent, was that the subject of the $1 billion Samsung?
No, that was the user interface, basically, kind of look and feel thing. Different. And there's some valuable patents that are owned by universities. So the recombinant DNA from Stanford and UC San Francisco, Columbia University patents on gene co-transformation, Northwestern on this drug, CRISPR, mRNA vaccine, Zygon from University of Minnesota, and you probably all know that this is probably the most valuable patent ever, that a university has been involved with, Gatorade in Florida. They've made hundreds of millions of dollars, or maybe that's an understatement, from Gatorade that the University of Florida has. I think the first one has made Stanford and UC about $450 million. The second one, almost $1 billion for Columbia University. Gatorade is estimated at hundreds of millions, but most of these are just rough guesses because it's not generally public information, but some of them are better guesses than others.
That's a patent, not a trademark?
Yes, it was actually a patent.
Well,
Well, so let's see. I think it was a set of intellectual property. So I don't actually remember how much was patent, how much was trademark, how much might have been other things. But yeah. And MIT's technology licensing office estimates they receive about $1 billion a year in patent-related revenues. So that's not trivial. Stanford's Office of Technology Licensing is supposedly brought in $59 million in 2023. So these are not small.
Was it $59 million for Stanford, but $1 billion for MIT?
It was like during 14 to 15 years. Yeah, sorry. And my patent related to face recognition was probably like 1 gazillionth of that, but still, it's kind of nice. But clearly, there is a long-tail distribution on money that universities make from patents. That there's a few big ones, those are probably most of them, and then there's hundreds, thousands of ones that are basically hardly bringing in anything, or probably in the majority of cases, they cost more than they actually bring in. So they're not, not a guaranteed revenue source, that's for sure. But a good example of this is the PageRank algorithm that Stanford students developed PageRank. An invention was done in the Stanford University context and their licensing office or whatever. And when they commercialized their research into this little company called Google, they had to license the technology back to Stanford. They had to license it from Stanford, and they ended up having this agreement where Stanford got shares of this new company being formed, and those shares eventually were cashed out for $336 million, which is a pretty good deal for the university.
I have a question about that. So, Microsoft has a search engine, and you would think that any search engine is going to need PageRank. Did they get around the patent, or did they pay royalties?
I don't know specifically for that question, but we're going to come to something that probably touches on that, at least at a higher level. So my guess is they just did. Let's just wait till we get to that. Okay? And it's coming soon. So what is a patent? Okay, here's an example of the first page of a patent. They're really boring, let me tell you that. They're kind of old-fashioned documents. They're just text. They're just black and white, with very occasional exceptions. There's no, audio. There's no animation, anything like that. But what it is fundamentally, it's a document that grants right by the government to an inventor that's exclusive. So this is just to you. That is a public disclosure. So getting back to what we were talking about a few minutes ago, it's telling the world what this invention is, and that is a requirement here for a patent. It's time limited. These days, patents are typically for 20 years. Changes a little bit on some other kinds of patents, but the typical kind we would care about 20 years from the date of filing. And it's also importantly territorial. So you get a patent for a particular country or territory. There's actually no such thing, even though you hear the term a lot, there's no such thing as an international patent. I'll come back to that in a couple of minutes. But so it is for a particular country or territory. Patents do not automatically enforce themselves either. So a patent gives you a right, but then somebody has to actually take that right if it's being violated or something like that. So there are three main types, and we're only going to care about the first type for today. There's utility patents, design patents, and plant patents. There's some others as well, but these are the main ones. Plant patents really are about plants. Okay, so I don't think any of you that I know of is working on plants, so we'll skip that. Design patents are really, the design of the product, what the Volkswagen Beetle looks like, or the iPhone looks like, or whatever. Utility patents are the things that we tend to think about and care about. Methods, machines, things like that. What's really important, sort of fundamentally about patent, are these four things. Some things are patentable, and some things are not. Okay, so patentable subject matter is one of these four key sections in Title 35 of the U.S. Code, Section 101, and it basically says what a patent is, or what's patentable, is any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. Okay? What that really means, like everything related to patents, is what lawyers and judges think it means. So that's a really important undercurrent of all of this. But to get a patent, you have to have patentable subject material to start with. And then you have to have something that's new. The thing you're asking to be patent has to be novel. If someone's done it before or done something really close to it, just can't do it. Has to be non-obvious, and what that really means in the patent world is maybe it's never been done before, but this part of it has been done, and this part of it has been done, and putting them together is just simple engineering that anybody would do if they were confronted with this problem.
In terms of novelties, so not described in a printed publication, but isn't there a grace period?
I'm going to come to that. And then finally, enablement and best mode disclosure. The patent actually has to give a written description of the invention and of the manner and process of making and using it, so that anybody skilled in the art who is reading this patent should be able to produce your invention. Okay? And there's a lot of, as you can maybe imagine, there's a lot of legal wrangling about, whether it's enough or not, for a given patent. So basically, you have to disclose it to the world. It has to be new, novel, and patentable. Those are the main things. And so when you look at this first page of patent, you see a bunch of things. There's a title on the patent. Okay, there's a number, the issue number of the patent. There's a date. It was issued on a certain date, which turns out to be important. There are the inventors. This one happens to be a face recognition patent from some people, including Hartmut Nevin. I don't know if some of you know him, but he's a VP at Google these days, who does a lot of, what does he do? Anyway, it was assigned to his startup company at the time, iMatic Interfaces. It was filed in 1998, and the date of patent was 2001. That's probably about average time. Maybe even a little better average time from filing to getting a patent issued. There's now these next few sections. There's related U.S. application data. So there was a provisional application for this patent. I'm going to talk in a minute what that means. But a related application by the same authors, same inventors. There are various references that are cited in this patent. There's patents, other patents, existing patents. There's foreign patents, so patents both U.S. and foreign can be referenced. And there's other publications, and this is where you're more likely to see academic publications. You're looking, is there a particular, there's Pattern Recognition Journal, there's PAMI, there's graphics and applications. Yeah, you don't see them that often in patent applications, but sometimes you hit one where, oh, I recognize all these venues. And then there's the abstract, which is just a very brief description. And then it tells you what's to come, which is basically 21 pages of figures. And at the very end, there's going to be 42 claims in this patent. Okay, so the title page tells you a lot about what's to come. And I will say that the abstract, much of the time, has absolutely no relation, seemingly, to what is actually the invention, for a few different reasons. And the bulk of this paper, the bulk of a patent, is in these two sections, so the figures and the specification. There are, probably 90% of the pages are in those two sections. But the claims are the most important thing in a patent. So before I go over a claim, so here is that patent, and we can just kind of, oops, sorry, you don't see that, do you?
to see this.
Here we go. Here is that same patent, and the first page that you've been seeing. Now, the second page with a bunch of the references, more references, figures, boring black and white sketches, many pages of figures, and then finally starts the specification, the actual, narrative sort of patent. And there's like a lot of words, a couple equations in here. You can tell that academics did this because there are equations in it. And then finally, the last 2 pages have the claims here. And they all start with what is claimed is, and then number 1, number 2, number 3, etc. So claims are the specific things that the patent's saying, this is my invention. Okay? The specification, the many pages of writing before that are basically describing lots of things, but then the claims are the very specific invention. What is what you're asking to be legally protected. And there has to be support for those things in the longer specification, but those are the details. There are independent claims and there are dependent claims. And there are claim limitations. These 3 things are important to understand. So here's an example of the first 5 claims of this patent, shortened a little bit so I could fit it on this page. And here's my diagram of how those relate. There are 2 independent claims, 1 and 5, and there are 3 dependent claims. So they kind of depend, 2, 3, and 4 depend on claim 1, and then 5 is separate. So dependent claims and independent claims are both very important for various reasons, but what they do is, again, spell out what the invention is. Here are 3 what are known as limitations. So limitations are basically things that limit a particular claim. You can start out with saying, I'm claiming the world, but only this part of the world, and only at this time of day, and only, so each limitation limits your claim. What that thing is that you're asking for protection for. So we can think about that structure and the words that go behind them. And I think of a Venn diagram when I think of these, is that we've got 2 independent claims, 1 and 5. So of this space of possible inventions, this describes claim number 1, and this describes claim number 5. They're like boundaries in invention space, basically. I own everything, or I'm applying to own everything. Or if the patent has been given, then I do own everything in this space of 1 and in this space of 5. And the dependent claims are subsets of the independent claims, which is a little strange. If you've read or even done your own patents, you probably think of dependent claims as kind of adding to the things they're depending on, but they're actually taking away from the things they're depending on.
I assume the reason is that they may be easier to defend because they may be truer.
Exactly.
So
Truer, as in most of the claims are actually false in the sense that someone has done that.
I wouldn't say truer, but I would say is
More defensible.
the broader one's probably been done.
That's what I'm saying.
Yeah, more defensible.
The novelty.
More defensible.
And a quick question.
Yep.
Maybe you're talking about this, but is what is checked in the patent application that the patent office sends it? Is someone going to check that you are correct about novelty, for example?
Well, everything is checked. How well it's checked, how thoroughly it's checked, and who is doing the checking, are the questions. And generally the person responsible, the patent examiner who's responsible for doing that, doesn't have your background and is relying on various things. So lots of things get through the patent system that probably shouldn't. So it's probably your point, yeah.
So an analogy I would like to think about is a peer reviewer.
Yeah.
So a patent examiner is he as good as a peer reviewer?
No, because the peer reviewer is in your field.
CVPR?
The patent examiner is not. So think about all the terrible reviews you've seen and perhaps received. I mean, not here, but other places. Our colleagues have probably received bad reviews, right? Poor quality reviews. Because all of ours say you're wonderful. But so yeah, it's worse than that in general.
How do the reviewers get whatever expertise they need to judge novelty and
Most of them have an undergraduate degree in some science or engineering area, and then they go to law school, And then they take a test for patent examiners, and that's what gives them the qualification.
So there are no experts involved.
They're not. I mean, they can bring in experts. I don't know how often that happens. So they rely a lot on what you tell them. And then their ability to determine the truth of that or not. Sorry?
Sorry, I just said that explains a lot.
Yeah, it does explain a lot.
Do you know if, I'm sorry.
So when your application is granted, let's assume it's granted.
Yeah.
Can the granting specify a subset of your claims, or do they always grant all your claims?
Once you actually apply, that begins a period known as patent prosecution. And that is where this back and forth can go on for even years, certainly months and possibly years. And during that process, the boundaries of the claims that you initially put in can change a lot. The claims can disappear.
The text of the patent can change.
The text of the patent can change as well. Not too much, I guess. There are limits on that, I think, but text can change. But certainly the claims can change. It probably usually do, at least somewhat.
So I guess two questions. So that's a discussion with the inventor then? They
Yes,
come back.
between the inventor and the patent examiner,
And then
U.S. Patent Office.
What, do you know the rate at which patents are, patent applications are granted?
I actually don't know. My guess is like, 20% or something like that. But so I want to talk a little bit about these boundaries and infringement. So as someone said earlier, you want what you're claiming, what you're owning, to be as large as possible, right? Because then you can make money off of that somehow, or exclude people, or whatever you want to do with it. But if you try to invent the whole world, they're going to say, well, no, that's already been done. So there's this kind of trade-off between large and small, right? But then the other thing is, you don't infringe a patent. You infringe a patent claim. Okay? So if someone's going to infringe your patent, it's going to have to infringe one of your claims. And there are two ways of doing this. I won't go through the details, but it can do exactly what you claimed or substantially the same thing as you claimed. So there are various options there. But here's the key. So let's say someone does that check mark in the space of inventions. They have not violated your patent, right? They've not infringed it. If they do that, they've not infringed your patent. If they do that, they've not infringed your patent. But if they do any of those things, the red X's, they have infringed your patent. Infringed either claim 1 or claim 5 or claim 2 or 3 or 4. Okay? And you can ask them not to politely, or you can try to get an agreement with them, or you can sue them, or whatever you want to do.
If it's a company and they say their technology is not disclosure to any party, how would you know that they are using your patent?
That is a very good question. So the question is, how would you know if someone's infringing your patent? In certain cases, right? And there's a lot. I'm sure there are tons of infringement going on that nobody knows about. Maybe even the infringers don't realize that they're infringing. Sometimes they do. I think a lot of times they don't. So a lot of this starts with either a whistleblower or just more likely a lawyer who says, that looks pretty similar to your patent. Let's investigate it. And you don't have to have proof to begin an investigation. All you have to have is a reasonable argument that I believe that they are infringing our patent. So it can be done just on,
Inspection.
look and feel or expectation or whatever, as long as it's reasonable.
Just to clarify, these are civil matters, right?
Yes.
So there is discovery.
Yes.
So if you sue someone and they say, no, we didn't infringe the patent, you can still go ahead and they have to give access, which is complicated. You have to protect their rights too, but someone has to look at their code and check if it's violated your patent. And if your claim is false, you will pay for it, I think.
Typically, yeah. So it is very complicated.
There is some protection against frivolous.
Yes. Yeah. So besides infringement, the other thing that's really important is validity. Okay, is your patent valid or not? Just getting a patent issued is just the beginning. It's not the end. A lot of things can happen from there to chip away at it or to completely nullify it. And there are something called derivation proceedings, which is basically someone else stole my idea. There's post-grant review, or derivation proceedings is they stole my idea, so that patent shouldn't be valid, or shouldn't be continued on to being valid. Post-grant review is that patent that just came out recently shouldn't be valid, and here's why. So let's squash it. Inter parties review, RPR, really important these days. That patent that's been around for a long time, perhaps, shouldn't have been issued in the first place, and it's invalid, and here's why. There's a lot of those going on these days. And then if your patent, if you say that you're infringing my patent, and you start a lawsuit about that, they can turn around right away as part of that lawsuit and say, your patent shouldn't have been issued in the first place. And so that becomes a whole new thread in that litigation. So there are a lot of ways in which either pieces or even completely your patent can be thrown out. And so it might not be useful at all. It might not have any value at all. You don't really know until it sort of hits the courts or gets wrapped up in some kind of licensing agreement, which is a positive thing. So here's the most important thing from this part, from my perspective. So let's say you have this patent that I've described earlier with these 5 claims. 1 and 5 are the independent claims, 2, 3, and 4 are the dependent claims. Now someone comes along and says, claim 1 is invalid. Okay, through one of those methods before, you've invalidated claim 1. What's left? There's sort of 2 obvious choices, right? Only claim 5 or claims 2, 3, 4, and 5 are left. Anybody?
Only claim 5.
Only claim 5. Who agrees? A few people agree. Okay, who thinks it's the other one? Okay, you guys are right. So what's left is this. Okay, and that kind of goes back to saying because these limitations or also these dependent claims are subsets of the independent claim or the parent of the dependent claim. And so if I invalidate claim 1, I'm not saying that everything in the space of claim 1 is invalidated. All I'm saying is that you can't own that whole space. That's what invalidating a claim is. Okay? So I say you can't have all of 1. That's what I've accomplished by invalidating your claim. But if you did dependent claims, and maybe you were very wise to do so, you still have stuff left there that you can still own and still license or sue people for or whatever. So it's an important thing. It's a reason to do dependent claims in a patent, and maybe lots of them. So an example would be, claim 1 could have been all cars that do the following thing. And claim 2, the dependent, could be all red cars that do that following thing. Okay? So if 1 has been invalidated, you can't get a patent for all cars doing that thing. You still have the all red cars doing that thing that you own.
If I infringe a patent claim and then that is determined to be invalid, can I ask for the money back?
You can ask. I don't think you'll get it. I think that's completely a legal question that I don't know exactly. It depends on the circumstances, but in general, if it's already passed, it's probably not. But maybe a smart lawyer could make that happen. So somebody asked about the timeline earlier, and I think this is sort of a key slide to all of this. So here's the typical timeline of a patenting situation. You come up with the idea or invention. Maybe sometime after that, in anticipation of patenting it, at some point, you might have a possible disclosure, which might be like a conference talk, for example. I did this great thing, I'm giving a conference talk about it. In some countries, that would say you can't patent it anymore. You've disclosed it publicly, no patent opportunities. In the US, that doesn't stop your patenting opportunity. You can disclose it, you have the grace period, which is a year to still file a patent application. Okay? It's a little risky because someone else could invent that during the year and you would not then have priority over that person. Because in the US, it's first to file, not the first who invents. Okay, but you do have that grace period. You have a year to actually do your first filing. So during that time, you can do a prior art search, see what's out there, has this really been done before? You work on the application, and then you can file what's called a provisional application, which is basically just a placeholder. Provisional says, okay, I'm going to be filing a regular non-provisional application at some point, but for now, let's just put a place mark here. It's very cheap to do this. You still have to sort of write the whole thing or most of it, You can't like add brand new material in this next round, but still, it's sort of a quick and easy placeholder to do. And then within a year, you have the opportunity of applying for a real patent, so the non-provisional filing. None of this gets published. This does get published. So after 6 to 18 months, depending on the situation, the patent office will actually publish your application. So it's getting it out there. Remember, it's part of this trade-off with the government. You're giving me something, and this is what I'm giving you, the ability to tell the world about this invention. Once you do the non-provisional application, the real patent application, that's when this examination, this process starts, the patent prosecution starts, and that's when the patent office attorney, does all the work, and you have all these back and forths for months or maybe years, and eventually, if you're lucky, you get the patent actually granted or issued. And then you can start dealing with licensing and commercializing and the fees you have to pay afterwards and everything else. But the general timeline is fairly straightforward. International patents, not much time, so I'm not going to say much about this, except, as I said, there's no such thing as an international patent, but there is such a thing as an international patent application. So you can file one thing to this PCT organization or PCT enabled this, that says, here's my patent that I want to get, here's the invention that I want to get patented. Now, 150 plus countries around the world are going to give me feedback from this one application. And based on that, I can then decide what to do internationally. But at that point, then I have to decide, am I going to get it patented in China, in Japan, in France, and in whatever country or territory. So it doesn't do all that part for you. But it is very valuable in the sense it will give you feedback, it gives you a report, it will give you some sense of how much value might I get from applying in all those places. Yeah.
So if I file the patent in the US but not in Japan, the Japanese company goes and implements it,
Yep.
and then comes to sell their stuff in the US, do I have recourse?
Yes, you do. So if they implement it and sell it only in Japan or anywhere else in the world, you have no recourse. But if they import it into the US in any way, then you got it. All right, patent costs, just very briefly. Patents are expensive, okay? And there are costs, that timeline that I showed a couple slides ago, there are costs sort of all along the way, and they tend to get larger and larger as time goes on, and then maybe steady off for a while. So through the 20-year, plus the pre-application timescale of a patent, you can spend, there are various estimates you'll get in cases, but $56,000, $40,000, $100,000 depends on a lot of things, and plus there's potential litigation and all. So patents can be expensive, and that's in a sense why you as TTIC students or faculty can't just tell TTIC to patent your great idea. We have to make a kind of a business decision of whether that's worth doing or not. So there's a lot to say about federal funding, which I'll basically skip, but you might have heard of the Bayh-Dole Act, or if you haven't, something you ought to be a little conversant about perhaps, but it's basically the rule since 1980 that we have this arrangement, that I described earlier with government funding and the ability for the institution to own the inventions and to license them to the inventors. Before that, the government owned everything when it gave federal funding for something. So it's been much better since 1980. NSF very much participates. If you've had NSF grant funding, then you will have signed some sort of agreement that has words like that in there about their adherence to the Bayh-Dole Act, basically. IP, I think, affects your research in various ways. You don't want to use an IP-protected piece of IP-protected code or something like that in your work or idea because you would be liable for it. Okay, I'm just doing it for research is not a valid excuse in the United States. It's not a legally workable excuse. Software patents, yeah.
Why? I'm sure, for example, transformer is a patent. People are using transformer.
I don't know if they have a patent for it, or they might have a patent for it and still open it up to the world. There are lots of legal ways to do that, so I don't happen to know what the case is there.
For example, neural network has one. You just show that.
Yeah, but remember, there's a 20-year time period. Actually, back then, there was probably a 17-year time life of a patent. That was long before, more than 20 years ago. So yeah, there are lots of interesting questions about, how can I use this? Shouldn't this be patented or whatever? And maybe it is, but it depends on how they decided to license it. In many cases, it's much more valuable for you to get your idea and invention out there, have people using it, then they get hooked on it, and then you can make money in other ways, than just the patent licensing. So a lot of models there. All right, software patents. This is another whole topic that I figured I probably wouldn't have time for, but it's a very gray area. What can be patented and what cannot be patented in software? Isn't software just an abstract idea and that's legally not patentable? It kind of depends. So it's a very big area of legal discussion right now. Almost every patent that gets challenged gets thrown at, this is just an abstract idea. And any computer science software kind of patent that gets challenged, that's always one of the ways of attacking it. So it's an interesting ongoing area. So why patent? Lots of reasons to patent. Some of it might be money, but there are probably better reasons, to patent. And think about patenting your things that you invent. Maybe it's because you want to do a startup. And the one from TTIC that I can point to is Mark Holland, who was an RAP several years ago. Started a company with a colleague, and we keep getting communications from them every year about, do we want to invest in their next round, round A, round B, round C, things like that. And we haven't, but I think they're doing well, which is nice. And those are some of my colleagues that I did a startup company with years ago. Bottom line about university situations is that they can be really helpful. I think MIT and Stanford are two examples of universities who tend to be really, really great in terms of their students and faculty and intellectual property. And they can be not so great, like UCSB was some years ago, and they can be terrible. So it really kind of depends.
Sorry.
All right, so summary. Intellectual property, especially patents and copyrights, is an important part of our general research ecosystem that we're part of, whether we participate in it or not. And I'm definitely not saying everybody should be patenting, okay? Not at all. But it's part of our ecosystem and it's important. So there's this broad network of participants in that ecosystem, the government, universities, and others. And this effective social compact has been developed between the government and universities, particularly in this Bayh-Dole Act and such, about how it can work well and benefit everybody involved. Patents and copyright are two key components, but it is important to remember they're not static. They're changing all the time. Like this gray area I mentioned with software patenting, that's kind of changing all the time. As we've talked about, copyrights with generative AI and such is changing a lot right now. So it's interesting and confusing. And of course, patents can be expensive and they can be limited in value because of the time period and because of other things. But they can also create really exciting, interesting opportunities. So I think it's something that everybody in academia ought to at least have some sort of working knowledge of. And let me just end by advertising our panel next Wednesday. 4 of our board members who have very highly placed academic positions are going to talk to us about the state of U.S. higher ed and research at 11 o'clock on Wednesday. So sorry I went over, but I'll stop there.
So we're a little over time, but maybe we have time for one question.
We'll just leave if you have. I won't be offended. All right, thanks.